apologize for the delay. We're waiting for the computer to update itself. This is an adjudicated proceeding in the matter of Gaston Cornu-Labat, MD, is licensed to practice as a physician and surgeon. The specific nature of this hearing concerns the reinstatement of Dr. Cornu-Labat's credential. This is case number M 2010-84 and license number MD 000-40392. The date is December 12, 2011. It is now 9:06 in the morning here in the Tumwater hearing room. Present in the hearing room today are Dr. Cornu-Labat, respondent, represented by his attorney, Keith Scully. Also present is Kim O'Neill, Assistant Attorney General, representing the Department of Health's medical program. A panel from the Medical Quality Assurance Commission is present, and I will introduce them. To my far left, your right, is Dr. Leslie Berger, who is serving as panel chair. To his right, my left, is public member Michael Concannon. To my right is Dr. Frederick Dorr, and to his right is Ellen Harder, public member. My name is Frank Lockhart. I've been designated by the Commission and the Secretary of Health to serve as presiding officer in this matter. These hearings are being conducted according to the Administrative Procedures Act, Chapter 34.05 RCW, and the Uniform Disciplinary Act, RCW 18.130. We are digitally recording this system, and that's what the delay was, is allowing the system to boot up. And that means that there are microphones at all the desks, and these microphones will pick up anything that anyone says in the room. So if parties need to confer with their client or anyone else, you can certainly take a break and step outside the room to do that. If the clock is running, that means that the system is recording. The panel has been provided with several documents. The first two are copies of the original order, which directed the respondent to undergo certain evaluations, and the copy of the final order after hearing suspending the respondent's credential pending completion of those evaluations. And the final three exhibits are copies of the evaluations that the respondent completed. Reinstatement hearings, by their nature, have a history to them, and so perhaps as a way to facilitate the proceedings today, I would ask Ms. O'Neill to briefly summarize the history and to state the department's position, and then I'll ask Mr. Scully if he has an opening statement he'd like to make. Ms. O'Neill?
Very good. Thank you, Your Honor, members of the panel. As the exhibits before you show, we are here because Dr. Cornu-Labat's license was suspended by an order that was dated April 29th, 2011 and served on May 4th, 2011 for failing to comply with an order that the Commission issued, which is also one of the exhibits before you, that ordered him to undergo specific examinations. That order was requested on the basis of a self-report that Dr. Cornu-Labat made to the Medical Commission, indicating that the Quincy Valley Medical Center, where he had privileges and where he was employed, had directed him to the Washington Physicians Health Program with a request that he work with them and follow their recommendations. We were later informed by the hospital that he had failed to follow through with the Washington Physicians Health Program, and that his employment had been terminated and his privileges had been revoked. On the basis both of the self-report and the information about the privileges action and the employment termination, the Commission did file a notice of intent to order an examination of Dr. Cornu-Labat, supported by exhibits. Dr. Cornu-Labat filed a response resisting, contesting that notice, also supported with multiple exhibits. The Commission panel considered all of those documentary exhibits and issued the order requiring him to get the examinations, which is Exhibit 1 before you. Dr. Cornu-Labat failed to do so within a reasonable period of time, and so a statement of charges was issued charging him with failing to comply with that order. That resulted in a hearing before a Commission panel at which Dr. Cornu-Labat appeared. Both sides made argument and presented additional exhibits, and that Commission panel ordered Dr. Cornu-Labat to undergo specified examinations, giving him the choice of 2 providers from whom to seek those examinations, and specifying in a protocol what the commission wanted those examinations to cover. That order is Exhibit 2 before you. The other 3 exhibits that you have are the examination reports that have resulted from Dr. Cornu-Labat having agreed to and having completed the commission-ordered evaluations. There are 2 exhibits, one from Dr. Vandenbelt and one from Dr. Muscatel, and then a supplemental report, which is the 5th exhibit, from Dr. Vandenbelt after he had an opportunity to review Dr. Muscatel's report. As a result of that, Dr. Cornu-Labat has complied with the Commission's directive, and therefore it is the Commission's recommendation, or the Department's recommendation, that he be reinstated. The order that suspended his license indicated he was to be suspended until he had satisfactorily completed the examinations that the Commission ordered. The exhibits before you demonstrate that he has now done so, and both based on their content and the fact that the order indicated that he was suspended only until he completed those examinations, it is our recommendation that he be reinstated. The order that suspended his license indicated that he should appear before a commission panel as soon as possible after the examination results were available, and we have asked for this appearance on the basis of that language in the order. So that is the extent of the Department's presentation, unless there are questions from the panel.
Why don't we hear from Mr. Scully, and then we can take questions for either side. Mr. Scully.
Thank you. Mr. Lockhart, I don't feel the need to do formal opening evidence and so forth. We agree that the exhibits are properly admitted. I have probably 3 or 4 minutes of comments, and I believe Dr. Cornu-Labat would like to address the panel at some point in the proceeding, and I'm happy to do that as a formal question and answer, or to expedite things, he can just speak. In terms of our position today, we are present based upon the Commission's final order suspending Dr. Cornu-Labat's license from April 29th. And that order has effectively 3 parts. He had to be evaluated. You were to evaluate whether those examination results provided any evidence that he was unable to practice with reasonable skill and safety. And then he had to appear back in front of you to decide if any further action would be taken. The basis of the suspension is RCW 18.130.170D, which provides that any suspension shall not be more severe than a suspension of the license until such time as the license holder complies with a properly ordered mental or physical examination. So it is our position that the suspension itself should be lifted effective today, because there is no longer a legal basis for it to remain in place, given that he has completed all of the examinations that the Commission ordered. The second part of the Commission's order were for the Commission to determine whether those examinations resulted in a finding that he was unable to practice with reasonable skill and safety. I'd like to just direct your attention to 2 sentences. The first from Dr. Muscatel's report, which is Exhibit 3. It concludes, "It is my opinion he does possess the requisite neurocognitive capacity to safely practice medicine." Second is from Exhibit 4, Dr. Vandenbelt's examination. It concludes, "In summary, there is no evidence that Dr. Cornu-Labat has any mental health condition or any mental health condition that has or would potentially interfere with his ability to safely practice medicine." So it is our position that based upon those conclusions, the second part of the Commission's order has also been met, and there is no reason to believe that Dr. Cornu-Labat is unable to practice safely. The third part of the Commission's order is whether any further action would be taken. And it's our position that under the lengthy and tortuous facts of this case, there is no basis to impose discipline, nor is there any basis to believe that there is any concern at all about his ability to practice as a physician. This matter started when Dr. Cornu-Labat was employed by the Quincy Valley Medical Center. A period of time, fairly short period of time, when some allegations were raised about his performance. During that period of time, he was chief of the medical staff. He had an active surgical practice. He served as interim CEO when the chief executive officer was unavailable, and he was tasked with a special project evaluating QVMC's processes and procedures. He's also a father of 3, and he was busy trying to parent and be a husband during this period of time. What happened was, during the course of that special project, he came to believe that one of the key problems at QVMC was not the way the systems were set up, but some of the staff and how they approached their jobs, whether they were qualified to do their jobs, and how they interacted with other employees. He began work on a report that was highly critical of the CEO and highly critical of other staff members. Shortly after that, some allegations started being raised that ranged from the bizarre, such as that he dared to take vacation, to the slightly more serious, including one that he showed up at the emergency room late at night smelling of alcohol. QVMC conducted an investigation, and tellingly, none of the allegations were sustained. The allegation about using alcohol was discovered that there was a patient in the ED that smelled strongly of alcohol. No staff member, other than the one who raised the complaint, had indicated that Dr. Cornu-Labat had been drinking that night. Despite the fact that all of these minor and non-patient care allegations were found unsustained, QVMC ordered, and I'm using air quotes there, Dr. Cornu-Labat to undergo an examination with the WPHP. Dr. Cornu-Labat consulted with me. I didn't see anything in that contract that allowed them to order him to do that kind of an evaluation. They were able to refer him, but he could choose, and he did choose, not to participate in the process because he did not believe, nor was there any credible evidence to suggest, that he needed to participate in the Washington Physicians Health Program. He self-reported all of those allegations. I believe that he was hopeful that the commission would do a broader inquiry into what was going on at QVMC, whether it was being well run. That is outside of the commission's ambit. On a self-report, all you do is look at the particular physician with the report. Dr. Cornu-Labat exercised his due process rights throughout. I submit there is nothing he has done during the course of this process that is anything other than appropriate and a logical decision he made. We are before you today with 2 completed evaluations indicating that he has no mental disease or defect. There have been no patient care complaints about Dr. Cornu-Labat, and the allegations against him, either considered individually or as a whole, raised no concerns about his ability to practice as a physician and surgeon. So we submit that there is nothing more for the commission to do today than reinstate his license and close this matter. Thank you.
Thank you. Let me ask, does your client wish to make a statement, or does he just want to respond to any questions that the panel might have?
I believe he'd like to make a statement.
Is that statement going to be in the nature of testimony or just argument?
It's predominantly argument.
Is there some testimony in there?
I haven't previewed these, but I know he wants to address the commission about this process. And I'm certain it will be argument. If it devolves into testimony, you feel the need to swear in, I'm happy to step in a more formal role.
All right. Dr. Cornu-Labat, you have the floor.
Yes, thank you very much. I think really what I want to leave very clear here, and since Ms. O'Neill started by giving a brief description of this whole case, I want to clarify a few points that were not very precisely described. Mr. Scully has given reasonable description of what has taken place. But there's a few areas that need to be clearly clarified. And this started when I self-reported. This particular process started when I self-reported.
Let me stop for 1 second.
Yeah.
I'm aware that someone is recording this in the background.
Correct.
Are they doing that under your direction?
Yes.
I need to ask the panel, does anybody on the panel find that to be disruptive? No. I just remind the parties that the official record is the recording and any other recording process.
We are very aware of it, and we have been through this on the first hearing. Thank you. When I self-reported, not only self-reported the fact that concerns have been raised about my supposed questionable mental status, but I also reported to the commission that there were problems within QVMC that I had raised, and that I had been forced to interact with the WPHP, who is a subcontractor of the Department of Health, of the Medical Quality Assurance Commission. And my interactions with them, which were very well documented and presented as part of the files in this case, were absolutely disastrous and put in evidence an incredible bias from their part and a completely unprofessional conduct. When it was said by the commission, it was questioned that I had refused, and raised by the hospital that I had refused to interact with the WPHP. That was incorrect, because I never refused to interact with them. I interacted with them for a month and a half and put in evidence the poor job they were doing. And that is the reason why I did not get evaluated by them. This was part of my self-report. And part of the process that took on after that self-report was me presenting what now is being confirmed, that the questions that were raised regarding my supposed abnormal behavior had no validity whatsoever. I also made the commission aware that there were serious problems in the hospital, and that the Department of Health, being the commission part of the Department of Health, was facing a conflict of interest. And this conflict of interest was related to the fact that a lot of the problems that were put in evidence in QVMC were in part related to failures for several years in the processes of inspection of QVMC. So there were a lot of problems that were put in evidence by my actions that took me into a road that took 2 years of my life, because the only thing that makes sense to understand all these is either that the effort has been throughout this process to keep me quiet and to force me into silence, or at some point, hopefully, there's going to be some evidence that the commission, as part of the Department of Health, is going to participate in a process that is serious. And there's a question that has been burning in my mind all along, and it's a question from Ms. O'Neill as part of these. It's understanding you as a person and a professional. The question that has been burning in my mind has been, do you stand for what is right, for justice, for transparency, for honesty, or are you part of putting good professionals, honest professionals that make an effort to put in evidence injustice, to put in evidence those that maliciously and irresponsibly make use of institutional systems to cover their shortcomings and their misery? This question has been rattling my mind all along, and I want you to please take a look, because since I was 6 years old, I've been educated under the motto certa bonum certamen. This is a Latin expression that translates conceptually as fight the good fight. In practicality, it translates as what I have been going through for the last 2 years with this commission and with QVMC. Because I have felt all along, and the evidence is extremely clear, that all this has been an effort to silence a process of putting in evidence shortcomings of the system and people that use the system to cover their actions, and not a process to seek the justice and what corresponds and what is right.
Doctor, let me say that part of my job here is to make sure that what we do here today is totally within the jurisdiction that's been allotted to us. And while there may be great merit to these larger political issues, what we're here to do today is one small piece of that, which is to consider your reinstatement. And that is a big piece. It's not the total picture, but that's all we can focus on today. And I don't wish to in any way dissuade you from fighting the good fight. But what I want to do is to make sure that we accomplish what we set out to do today. And I know that the process you've gone through has been torturous. There's not a panel member up here who hasn't been through hearings where the process that any respondent goes through is difficult, expensive, and time-consuming, painful. And we do appreciate that. But the task before us today, and what I really want to focus on, is this one piece, which is the issue of your reinstatement. And in doing that, I don't wish to in any way dampen any other issue, but I just can't deal with it. I can only deal with the issue of reinstatement.
Sure, that's very understandable. The reason why I said what I said is because the first request was to give a brief, and this has been very brief, description of the process that took us to what we are addressing today. The last part is, which was mentioned, is that when the order was issued for me to get mental health evaluation, it's not that I didn't comply, it's that I actively refused to comply.
Well, I think that the exhibits do speak for themselves, and there is mention in there that you did participate in that, so I think that...
Eventually I did. Once I was out of resources to stand for my rights, obviously the logical consequence was for me to comply because there was nothing else. The whole thing was exposed completely for what it is.
Let us do this. I appreciate your comments. What I'm going to do is ask each of the panel members if they have any questions for either side. I think because what we did now is just what I call opening statements, is just a summary argument. I think in case they have any questions for you, specifically related to the issues that got us here, I do need to swear you in because what you say at that point would be under oath or affirmation. So if you'd raise your right hand, and do you swear or affirm that the testimony that you might give today in question will be the truth, the whole truth, and nothing but the truth?
I swear.